Florida Supreme Court is now in session. Please be seated.
Our second and last case today is Johnson versus State of Florida, number 2023-0055.
May it please the court, I'm Steve Bulletin from the Bartow Public Defender's Office. I represent the appellant Tyrone Johnson. My intention is to argue the second interrogation video, which is 95% Detectives Florio and Tabor and 5% Tyrone Johnson saying the same thing he said all along. I also intend to argue the brother that went rogue and then was prevented from recanting by the state's heavy-handed and coercive threat of a perjury prosecution. If time permits, which I doubt, but if time permits, I may argue the trial court's legal error and misuse of two important mitigating factors to denigrate one another. In this case, the prosecutor set the table at trial for the second interrogation video in his opening statement to the jury. It tells them, "You will hear what Johnson said happened. It all happened in a bedroom, but you will find he's not a very reliable narrator." It tells the jury, Detective Florio and Detective Tabor gave him every opportunity to explain what happened. And he says, no, it all happened in the master bedroom. However, the prosecutor tells the jury, foreshadowing what they will later hear from Detectives Florio and Tabor on the second videotape, opening argument, the evidence doesn't lie, ladies and gentlemen. Individual can say whatever he wants to say, but the evidence doesn't lie. Moments later, for still more emphasis, the evidence doesn't lie, ladies and gentlemen. And then when the second video played...
Could you quote the prosecutor, right?
I'm quoting the prosecutor talking to the jury.
Okay, but on this issue, it's really about what's in the interrogation. Yeah. What's the worst thing that the officers said, from your perspective? The most harmful thing and the most inappropriate thing that the officers said in the interrogation?
Okay, I don't think the officers said anything inappropriate in the interrogation. As my opponent points out, this is standard operating procedure for a confession, not for an interrogation. The problem wasn't what the officer said. The problem was it getting in over defense objection before the jury, when all the jury really heard was the steady drumbeat of what the officer said. And what Mr. Johnson...
What did the officers say that was the basis for that?
Okay, what the officer said that was the basis for this. There's also evidence to show that the young man was more than likely trying to get away from you. It appears that what you were telling me doesn't make sense with the scene. If what you tell me doesn't make sense with the scene, because the thing is this, man, and I've been doing this job a long time, I know that the evidence will never lie to me, but people will try to minimize and try to make themselves out to be something that's not. I hope it matches your story. What I'm being told right now, it doesn't. Do you want a tragic situation where shit went bad, or do you want Tyrone is manipulating anything, and he murdered his girlfriend, and he chases her 10-year-old son throughout the house, killed him, and dumped his body next to his mother? We need you to tell us what happened in Rye's room. We know something happened in there. How did you get to Rye's room? Tyrone, I'm going to have to disagree with you there. So it's very possible you could have moved from the master bedroom to Rye's room because Rye was scared and he was trying to get away from you. So there's only one explanation for the shell casings and the bullet holes in his room. Now maybe this is what you were telling me, and what I more than likely be able to prove are two very different things. Tyrone, I'm not out to get you or anything. I just want you to tell me the truth. And then basically, this is your story and you're sticking to it, right? Okay? What you get back from Tyrone, and this is the 5%. I don't know, sir. I didn't go in Rye's room. Everything happened in the bedroom, and a lot of inaudible. Okay, again, Justice Kennedy, I am not contending here that I've seen many interrogations just like this, in some cases worse, where they're actually coercive. I mean, if Tyrone Johnson had done what
there are statements like, we know you did it, and there's nothing direct like that. They're dance around it, but there's nothing that says, we know you went into the bedroom and murdered him.
I would have to respectfully disagree. I mean,
you think it's the equivalent of that?
I read this as we know you went in the bedroom. The evidence shows us we went in the bedroom.
But
With
of course,
this
the evidence does show that. I mean, they're pretty overwhelming.
Yeah, no, I see what you, overwhelming evidence is not the test here. What I want to get to here is, okay, the prosecutor knew that this would have an impact on the jury, otherwise he wouldn't have done it. Now,
But isn't the real impact on the jury the blood under the bed and the bullets?
then why introduce the second videotape? I did a notice of supplemental authority on a 1919 case, it's called State versus Gun, cited again in 1968. Old case, but I think it's still good law when you consider the Julio standard as reaffirmed time and time and time and time and time again, says overwhelming evidence is not the test. The test is, could this have had an impact on the jury's deliberations? Could this have, the prosecutor knew it would have an impact on the jury, or he wouldn't have fought so hard to introduce it.
Your argument is that what had the impact on the jury, let's be specific. It's not the video. You have to show that what had the inappropriate impact on the jury's deliberation is what the officers said in the video. Isn't it true, though, that the state had every reason to introduce your client's denial as evidence of your client's evasion and state of mind about the murder?
They already introduced that in the first part of the video.
Okay, but that's an argument about the potential cumulative nature of this evidence. It doesn't go to the prejudice of it. All the court needs to do in order for us to sustain its evidentiary decision is not abuse its discretion. And I can imagine a court in its discretion finding that your client's denial was relevant evidence about state of mind and how he's dealing with the evidence that he's confronted with. And therefore, it's not an abuse of discretion. And it isn't about what the law enforcement officers were peppering him with. I mean, help me understand how this constitutes the egregious case of bolstering law enforcement's story by putting them in a position where they're narrating a thesis, narrating a theory of the crime in the video, which I agree with you, like in the Jackson case, is problematic. Here, I just don't see that you have it, unless I'm missing something that I haven't recounted in my question to you.
Well, I think this is a lot like the Jackson case, save for the fact, okay, Judge Sabella, in this case, said, when I saw the Jackson case, it scared me to death. But I learned two things in, death penalty judge school. Wise judge said to us, number one, judge shouldn't get out of his lane and do things he's not authorized to do. But on the other hand, he also told us ain't much can't be cured by a jury instruction. Now, the jury instruction here, if you look at the preamble to the jury instruction, what it's for is it's for when something comes in that is admissible for one purpose, inadmissible for another purpose. Okay, the officer's opinions of guilt or credibility are never admissible for that purpose. But in some cases,
they're not proffering an opinion about guilt. This is an interrogation, and they're confronting him with it. It's not like they were called as expert witnesses.
I said right off, the officers didn't do anything wrong.
Okay.
What's wrong is introducing this unnecessarily and prejudicially before the jury. What this kind of comes down to is it allows the state to it's sort of cross-examination by the officers of a defendant who didn't testify. The state didn't get to do cross-examination. What they did a closing argument that was absolutely foreshadowed by what the officers did here. The officers are telling what you're telling us doesn't match with the scene. That's the prosecutor's closing argument. What he told you in the first video, it doesn't match with the scene. Okay, that's a problem. I mean, I'm not arguing sufficiency of the evidence here. I wouldn't have argued sufficiency of evidence in this case even before Bush. But what I am saying is this predisposed the jury, certainly in the opening argument, certainly when they introduced the second videotape, predisposed them to believe the state's view of the case. Now, you could say, well, why would we even have a trial here because the evidence was so overwhelming, the physical evidence? Well, maybe it wasn't as overwhelming as all that. I mean, it's problematic, to be sure. But there are, for example, I mean, under the state's theory, Stephanie was shot 3 times. Ricky was shot 6 times. According to the state's theory, Ricky was shot only twice in his bedroom. Only 2 cartridge casings are found in his bedroom. One somehow got kicked out onto the porch where nobody says any shooting occurred. 6 cartridge cases are found in the master bedroom. So that raises the question, if Ricky is shot 4 times in the master bedroom, including in some pretty serious places, how is it that there is only blood under the bed?
There's not. There's also a pool of vomit. Because
there's a pool of vomit that was never tested. There's no DNA that when that got there, anything about it. But yes, there's a pool of vomit. Yes, the pool of vomit is a problem. But you would think logically.
I don't think you want to argue sufficiency of the evidence. I think
I'm trying. Well, no, I'm not. I'm not. The evidence is absolutely sufficient. I'm arguing that number 1, the standard isn't overwhelming evidence, and number 2, the evidence may not be as overwhelming as everybody seems to think. I don't know why there wouldn't be blood, for example, blood trail in the living room that had to be crossed twice by Ricky to get into the bedroom, and then supposedly if Johnson is dragging or carrying the body back, there should be blood from that either on his clothes or on, I'm just saying that the defense's argument, and they have a right to, this was a trial. This wasn't just a star chamber where you start off, he's guilty, so it doesn't matter what the state does. The defense's argument was that the crime scene was compromised, and you can't totally go by that. The jury had a right to consider that. Okay, so I'm saying that by predisposing the jury with Detective Florio and Detective Tabor thought that Johnson's statement, Johnson's explanation of what happened was ridiculous. So they're predisposed to think that before they even hear some of the physical evidence, before they hear the prosecutor's closing argument. This is largely the Jackson case, and the jury instruction, like I said, the jury instruction would have been fine if the purpose of the jury instruction is for when, like in a case like Bush, where the interrogation would be admissible, but you caution the jury that don't consider the officer's opinions for their truth, only for their reactions, the relevant responses from the defendant. And that's fine if the defendant gives significant relevant responses. They were trying to get a confession here as to premeditation. They were trying to get a confession here as to Tyrone went into Ricky's room. Had they gotten that, this interrogation video would have been fine. Had they gotten anything close to that, this interrogation video would have been okay. But I cited a second DCA called Pausch for the proposition. They say, and the trial judge actually said in Pausch that, you're right, this video that I'm seeing here is 95% Detective Bonsall and 5% Ms. Pausch just saying the same thing she said all along. That's what we have here. That's why this was harmful, reversible error. And again, I don't think the state should be heard to basically say on the trial level, to fight to get something in. This is important. We need to get this in, and then come on appeal and say, well, we didn't need that anyway. That's like saying it's okay to stack the deck and then just say, look how easily we won the hand. It's like saying that the stronger the prosecution thinks its case is, the more error it can inject into the trial. I think that this case needs to be reversed for a new trial on that basis alone. Now, I want to get into what I call in the brief the Al Johnson fiasco. The state's argument, they went into, their brief is kind of more detailed, less superficial on other issues, but on this issue it's like a 4 or 5 page argument, and they don't mention any of the following things: email, perjury threat, Webb v. Texas. They don't address any of the Webb v. Texas due process case law. They don't say it's wrong. They don't try to distinguish it. It's just not there. Their entire argument is, well, nothing to see here, folks. There's nothing we can do about this, because they're treating the argument as we just got testimony from a witness that wasn't what we expected. Okay. It's like, well, that didn't go the way you wanted. Well, if that was the issue, number one, I wouldn't be up here arguing it, but that's not the issue. The issue is that Al clearly had severe misgivings about his jury testimony, and he was had indicated that he wanted, he doesn't use the word recant, but he wants to tell the whole truth now. He wants to paint a true picture of my family's darkest and most intimate moments. It's clear he wants to redeem himself for a performance that he said he left the courtroom feeling personally defeated. He's talking about, the family pressures of Tyrone and Stephanie they were what I would call mishpucha. They had relatives in common. They were all family. And Al was overwhelmed by the presence of family and by having to denigrate his beloved grandmother in front of her children and the presence of cameras.
Can I interrupt you for just one second? Before we get too much further down this rabbit hole, do you agree that we're talking fundamental error here? I mean, are we reviewing this particular, the Al Johnson, whatever it amounts to, doesn't it need to amount to fundamental error? I mean,
I don't think it has to be that.
Tell me how it's preserved, because if you're going to say the motion for a new trial, I don't see an objection that saves this unless, tell me if I'm wrong.
I think you have to consider the timing. Number one, I do think this is fundamental error. The case law.
Your argument is that, okay, should I take from your argument that it does constitute fundamental error a concession that we should be reviewing it for fundamental error?
No, and I want to get to that.
Please do. I want to hear that part first.
Well, all right, I'll do that part first. The sequence of events here is Al testifies in the jury penalty phase. Basically, contrary to converts himself into a state witness, and it's not like he would have provided additional corroboration for Dr. Mackless, as the state suggests. He put himself in conflict with Dr. Mackless. He testified before Dr. Mackless. He was a primary source as opposed to a paid secondary source. He was devastating, absolutely devastating to this jury penalty phase, cost Tyrone almost certainly the one vote he would have needed, or 1, 2, or 3 votes to prevent a death sentence. But then, prior to the Spencer hearing, which was scheduled for, I believe, early May, Al speaks with Jamie Kane, the defense attorney, on the phone. He's got real misgivings about what he's...
I'm sorry, counsel. I'm really looking for an answer to my question.
All right.
Are you conceding that the applicable standard of review for this is fundamental error or not? And
No.
if the answer is no, tell me how this was preserved.
How it was preserved is that after the perjury threat, the error doesn't become a due process error until Al testifies the way he did. Okay, the sequence of events, which is important here, is you got the email in April, the Spencer hearing gets postponed, you got a motion for a new trial being filed in June, which talks about Al's testimony, but doesn't specifically refer to the perjury threat. Then you've got the Spencer hearing occurs in July, where Al does what he does. Then in the hearing on the motion for a new trial, which occurs in September, which is then the defense argues, among other things, that the perjury threat coerced Al into...
Do you think that constitutes a contemporaneous objection that preserves the matter?
I don't think it has to constitute a contemporaneous objection, and here's why. This isn't like a trial error where the judge would have an opportunity to cure it. I am not arguing that we should get a new Spencer hearing. I am not arguing that this should go back for resentencing by the judge. The damage was already done. Al was prevented, that if the, defense counsel, could he have objected at the time of Al's testimony at the Spencer hearing in July? Sure, he could have, but it makes no difference in terms of sandbagging or anything like that, because the issue was we need a new penalty trial. So he does that in September at the hearing on the motion for a new trial, rather than at the Spencer hearing itself. If I was arguing he should get a new Spencer hearing, then I think you might have a point that the lack of contemporaneity of the objection may have been a problem. But in this circumstance, I don't think it is. If the court thinks it is, then I would fall back on, of course, fundamental error, because this, under Webb v. Texas and all of its progeny, is a due process error, and the cases are legion that say...
Related to this, describe the circumstances in which what you characterize as the perjury threat was made. Who heard that? Who heard the threat?
Who heard the threat at the time it was made, or who heard it eventually? At the time it was made.
What does the record show about who heard it at any time?
Okay, the record shows that the perjury threat was made at a hearing just before the Spencer hearing was scheduled to occur. Jamie Kane, the defense attorney, goes in there and says, I showed the state this email, and I think we might have a problem. The state then says, if he testifies any different than what he testified at the penalty phase.
Does the record show that the witness was present when that was discussed?
No, the record shows that the witness was not present.
Okay.
But the record also shows that it was immediately decided, oh, we got to appoint counsel for the witness to advise him. And what the record then shows that when he comes back to testify, he's been calling around trying to find an attorney, but he's been unable to get one, and he's can't afford one, so they appoint regional counsel. Initially, they appoint the public defender, which obviously there's a conflict. Then they conflict him out, and they appoint regional counsel, who's already there. Regional counsel, then there's like a 20-minute recess for regional counsel to consult with Al. Then Al comes back, and he's, contrary to his email, he's testifying that everything he said at the penalty phase was exactly true, and defense counsel is mischaracterizing the email. And he was absolutely enraged at defense counsel to the point where he gets declared a hostile witness. When defense counsel, at the state's suggestion, introduces the email into evidence, Al says, I need to talk to my lawyer again. The judge says, okay, in excess caution, go talk to your lawyer again. So he's actually talked to the lawyer twice. Now, do I have anything in the record that specifically, in the transcript where somebody's telling Al, hey, you're going to get charged with perjury if you do this? No, I don't have that. But it defies all imagination that this was not.
But your theory is somehow that his lawyer is the state's agent in coercing him?
No, he would have even had a lawyer if the state hadn't coerced him.
But didn't you just say earlier, though, that what you're saying is the problem is what happened at the penalty phase in front of the jury?
Well, see, this is a compound
threat wouldn't
thing.
have anything to do with that, right?
The perjury threat has everything to do with it.
I thought you said the perjury threat happened before the Spencer hearing.
That's correct.
Okay, so the jury part is done.
No, there was a motion for a new trial based on what Al had done. If Al had been able, if he had not been coerced off the stand, in this case he was coerced, locked into his previous testimony. Otherwise, he was looking at a second-degree felony in prison time. Had he not been coerced, the judge very well might have decided that what he did in the penalty phase compromised the reliability of the penalty phase and would have possibly, very probably, I think, granted the motion for new trial penalty phase, new penalty phase. I think that belief is bolstered by the fact that in his sentencing order, the judge believed Dr. Matlos as to the history of abuse and everything like that. There's nothing in the sentencing order that indicating that he believed Al's testimony before the jury. So the state says, well, there's no problem here because the judge's sentencing order was fine. Well, that's why I didn't argue that there should be a judge resentencing, why there should be a new Spencer hearing. There should be a new penalty trial, either because it was preserved or because it's a fundamental due process issue. I think a very important thing that shouldn't be overlooked is the prosecutor did not say, I am not going to tolerate Al testifying any different than he did in the penalty phase because he'll be perjuring himself because I believe what he said in the penalty phase was true. Prosecutor says, now we don't know which version is true. Was he lying then or was he lying now? I don't know. So let's lock him into his testimony. That's a huge, huge problem with the reliability of this jury penalty verdict, particularly in light of the fact that it requires unanimity. So if I have any time left, I'll move on to the sentencing order issue where the judge uses, this is not an abuse of discretion problem, this is a legal error problem, where he diminishes the weight of the impaired capacity impaired capacity mitigator because Johnson had an exemplary crime-free life prior to that, and he diminishes the weight of the no prior history mitigator by an irrelevant reference to a case and says, well, based on the circumstances of the case, I'm going to diminish the weight of the no prior history mitigator. The state kind of led him down that Primrose path by arguing in their sentencing memo that the two mitigators are mutually exclusive. They're not. If anything, they're complementary. I would cite the newest Bevel case, the 2023 Bevel case, for the proposition that for the impaired capacity mitigator, the defendant's capacity didn't have to be impaired through his entire life. It focuses on his behavior at the time of the crime, and the evidence here is really pretty compelling that Tyrone Johnson's life was unraveling. He had a tough life anyway, with the injuries from the military and his other problems, but in the last 2 years before this crime, his life was unraveling. He was Baker acted, he was at the VA for all kinds of problems, and then his son committed suicide. This, ultimately, what triggered this murder, by a guy who has no significant prior history of criminal behavior at all. What triggered this murder is his girlfriend, who had at least been drinking a little bit. There's a dispute over what to watch, whether to watch a football game on TV. And she says, I can see why your son killed himself like a bitch, because you're a bitch. Okay, to somebody whose mental state is already unraveling anyway, that is a cruel, horrendous thing to say. Not a justification for murder, I'm not arguing that, but certainly something that could trigger a murder in somebody whose capacity was impaired, as Dr. Mackliffe says it clearly was, that it was unraveling, and then the dam broke with that. Okay, what the judge says on diminishing that important mitigator, one of the more important ones in Florida law, is, well, I'm only going to give this slight weight because of his history of not committing crimes and because of his history of holding, good jobs with, the court system in South Carolina, his exemplary military service, whatever. All these good things are reasons why I'm going to denigrate impaired capacity. And then he turns around and on the no prior history mitigator, he says, well, I'm going to give this less weight because of the circumstances of the crime. And he cites a case called Ramirez. He says nothing about why the circumstances of the crime should diminish the no prior history mitigator. This guy's lived 40 plus years without committing crimes. That should increase the importance of the no prior history mitigator. But he cites this Ramirez case without explaining in any way how this triggered explosion of violence. What about the circumstances of this crime in particular denigrates the no prior history mitigator? Well, when you look at Ramirez doesn't say the circumstances of the charged crime. Ramirez is talking about the circumstances of a prior crime, which the judge actually used in Ramirez to diminish the weight. And this court said that was an abuse of discretion because the prior crime was relatively minor. It was, I think he stole $10 from a truck dashboard or something like that. So Judge in Ramirez, your statement, the circumstances of the crime, that's kind of meaningless. That's an abuse of discretion. Well, here it was an abuse of discretion to legally misunderstand two important mitigating factors based on some theory that they're mutually exclusive or they cancel each other out. As I said, the state led him down that Primrose path. It's not a question. Justice Labarga had asked a question in the last oral argument to the effect of why did the judge give only great weight to CCP when he gave very great weight to three other mitigators. And the CCP seems like a pretty big one here. Why did he only give it great weight instead of very great weight? And counsel for the state said, basically, I don't know. I mean, he could have given it very great weight, but he gave it great weight. Okay, here we know why the judge diminished the weight of those two mitigating factors, and we know that they were based on a fundamental misunderstanding of the law. I'll reserve the rest of my time for rebuttal.
Thank you.
May it please the court, my name is Christina Pacheco and I represent the state in this case. I will address the arguments as counsel has done so in that order unless the court directs me otherwise. Justice Coriel, what you said regarding the second interview, that the impact is on what the officer said, is exactly correct, and that is what this court has always looked at, what the officer said. In this court's Jackson opinion, it is focused on whether the interviewing officer or detective makes a statement that addresses the defendant's credibility or guilt, and that is what is improper, the statement that goes to the guilt or credibility. And in Jackson, there were repeated statements. Why did you kill her? I know you did it. I know you know in your heart you did it. There's no doubt in my mind that you did it, okay? There's no doubt. And it goes on and on and on as to statements that the defendant was guilty. As my colleague, Mr. Bulletin, concedes, law enforcement did nothing of that nature here. He said they didn't say anything inappropriate. They didn't do anything wrong. Well, we don't have a Jackson issue. We don't have an issue when the interviewing detectives are not making a statement. As Justice Kennedy said, there was nothing direct, and for that reason, there is no error. This is more in line with the Bush case, where the detectives confronted the defendant with the evidence against him and gave him an opportunity to respond. And that is exactly what the detectives did. They said that there's a big difference between saying, here's what the evidence says, or here's what the evidence is, tell us your story. What you're saying isn't lining up, then you're lying. We know that you're lying. And in Bush, the detectives actually misled the defendant insofar as they presented evidence that wasn't actually true. The detectives talked about NASA changing a video and tried to get the defendant to make statements, incriminating statements, and this court found that there was no error in that case. Here we have the defendant saying the detectives saying truthful statements as to what the evidence actually showed, and the defendant, and presenting the defendant with the evidence. Mr. Bulletin had said that we made a comment as to the state relaying that we didn't need the evidence, so it doesn't matter. That's not what we are arguing or what we had ever argued. We are entitled to the evidence. We were entitled to the evidence. It was relevant to our case. The defendant made relevant, incriminating responses regarding committing the crime, murdering. He didn't say murder, but he admitted to shooting both victims. He admitted that he was the only one in the house with a gun, that there was no one else there other than the two victims, and that he was the only one that had the gun. He admitted that there would have been no reason for the child Ricky to have any bullet holes in his room, that Ricky didn't have the gun before. He admitted to the time frame, which was important to the state's case, because he presented himself as, he did have an injury. There's no doubt to that, but he presented himself as incapable of going into the victim's room or chasing him because of his injury, although during the second interview he said that he left the apartment and there was a kind of like a sunroom outside of the door. He left the entire apartment and he went down to the front gate of the apartment complex looking for someone to help him, and then he turned around when he realized at that time, because his phone had been turned off, he realized that there was actually a house phone, so then he went back into the apartment and used the house phone to call 911. And he, according to his statement in his second interview, he said that he did all of that, went to the gate and back in under a minute time, which was important for the state to show, well, if you could hop on 1 foot that fast, then clearly he was capable of getting to the defendant or to the victim's room. And what also was important for the state's reason for admitting the second recording was, even though we did have the first recording, it is very difficult to understand the defendant during the first recording. It was taken right after he was arrested, and he was very upset at times, and it was just hard to even hear what he was saying. Some time had passed between the first and second recordings. His clothes had been processed, he had calmed down a bit, and it was much easier to understand what he was saying during the second recording. And so that also made it important for the state's case, in addition to just seeing his reactions when he was presented with the evidence, his explanation or lack of explanation as to why there was blood in the child's room, why there were 2 shell casings, why there were 2 bullet holes under his bed. Now, the important part about the bed is that the bullet holes were not visible as just looking at the crime scene after the murders. There was toys and kind of clutter under the bed. It was not until law enforcement moved the bed away from the wall were those 2 bullet holes visible. So the defendant would not have known that, probably did not realize that there were bullet holes in the wall. There were no other bullet holes in the entire apartment. Those were the only 2. So to see him getting confronted with that evidence as to, well, explain then why there's bullet holes in the wall, it was very important for the state's case to be able to show that. So there was clearly no abuse of discretion in admitting the recording, and even if this court were to find that there was, it would be harmless given that it was less than 14 minutes in length. There was a jury instruction provided. It was uncontested that the defendant killed the victims. In the Bush case, there were 4 videos, and even in the Shepard case, this court found that there was no fundamental error when officers were telling the defendant, tell me the truth, don't lie to me. So clearly there would be no harmless or harmful error in this case when the statements did not rise to any level of prejudice, like in the Shepard case or Jackson case. The Al Johnson issue, what's a bit puzzling about my colleague's argument is that he's saying that he's not asking for a new Spencer hearing. He's not asking, he's not asking for a new Spencer hearing. He's only asking for a new penalty phase in front of the jury. But yet the issue that was before the jury was just that Al Johnson didn't testify how they wanted him to. The focus on the email and what he calls the perjury threat, that happened after the jury penalty phase. So if only what he's asking for is the penalty phase, I think this court looks at, you're not entitled to a new trial because a witness doesn't testify how you want them to or expect them to. If that were the case, then we'd have new trials every day because it's very common for witnesses to change maybe not be as forceful or direct in terms of their testimony than they were comfortably sitting in an office discussing a case.
Well, I think as I understand the defense's point is that he made a statement that in this penalty phase, that he then later indicated might have been incorrect, and that was one of the basis for the motion for new trial, which was pending at the time of the Spencer hearing. And then when they went in, there were all these now issues surrounding perjury, enough so that the court felt it necessary for him to have his own counsel. So at what point should this issue have come up? I mean, because I think you're arguing it's not even a preserved issue. When should the objection have been made to make this a proper issue? Because it is a bit of a complicated timeline.
It is. I think, to me, it seems like we have to separate the jury penalty phase and the Spencer hearing. And if we are just looking at the jury penalty phase, to me, that is, you don't get a new trial because the witness testified differently. If he's arguing that it's a substantive due process violation based on this email and what happened at the Spencer hearing, in my opinion, that's a different standard. He did file a motion for a new trial, but it was a bit different than this independent due process violation. In my view, it's not preserved, but even if, whether it's viewed under the abuse of discretion standard or the fundamental error standard, he is not entitled to relief on that basis. I think it's important to look at the reason. Well, first, the email does not state that I lied during my penalty phase testimony, I want to testify again. As Al Johnson explained, he sent this email to put his emotions and his feelings down. He never said, I lied. And the state never perceived it that way. The state said on the record, I disagree with defense counsel's characterization of this email being a lie. Now, during the Spencer hearing, Al Johnson even said, I believe that my trial testimony has been mischaracterized and my email has been mischaracterized. But if we're looking at this due process claim, I believe Justice Kennedy pointed out that there was never Al Johnson was never around when this supposed perjury threat was made. What the state said is if you're going to have him come back to the Spencer hearing and say that he lied on the stand during a death penalty case, we are going to look into that, and that's perjury if he's going to come in here and say that he lied. And then at the next hearing, the prosecutor says, well, I had a chance to talk to Mr. Warren, and we're not sure what he's going to testify to. It really depends on how he testifies. And even the judge understood, well, if he's saying, admitting to some of these acts of abuse, but not labeling it as abuse, that's more of a subjective view. Because Al Johnson was admitting to a lot of the acts. For instance, he said his grandmother spanked him. In the country, they called it a beating. She used a black strap. But then he said it wasn't abuse. It didn't rise to the level of abuse. So the court acknowledged that if he's just kind of giving more information and not saying that he's lying, then that probably isn't a perjury charge or perjury.
Could I also, so as I understand it, the sort of the key moment in the testimony is the thing about the weird wedding day reference, and then he backs off of that and says, I don't remember anything about whatever it was that, the thing that tied in with the beating on the wedding day of their mother, right?
Yes.
Okay. So there's another element that neither side has raised, and that is that Dr. Mackless's testimony goes in unobjected to, and at most, Al Johnson's testimony would have been corroborative of Dr. Mackless's statement after 14 hours with the defendant that she could say that he gave her plenty of evidence that he had had a childhood full of abuse, right? So at the end of the day, isn't it, I mean, we're having a very interesting argument about this sort of peripheral issue about Al Johnson's testimony. I want to sort of bring us back to the weight, or like what it ultimately would have proven. It would have ultimately just corroborated what the jury heard anyway. Am I wrong about that?
No, Your Honor, that's exactly correct. Dr. Mackless testified in detail as to what he the abuse suffered by Al and Tyrone Johnson, and he said that both Tyrone and Al told him about the abuse, and that it was also confirmed it was multi-generational, and that he went over everyone in the family. There were aunts, the father, various people talked about the grandmother and her infamous black strap, and the jury heard all of that. I believe that if we're looking at this in terms of perhaps if Al would have testified differently at the Spencer hearing, it really wouldn't have mattered in terms of the abuse. The judge certainly had the email, had both testimony. It's the judge's function to be able to look at all of this and give it appropriate weight and not be misled or confused about any difference in testimony. The judge credited Dr. Mackless's testimony throughout his sentencing order, and I think it would be improper to say that there would be any sort of confusion or misleading based on if Al would have given more information about the abuse. The impaired capacity mitigator in the judge's sentencing order, there was no legal error with the judge's analysis of that mitigating circumstance. What happened is Judge Mackless testified that the defendant's ability to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired, and he said because of two reasons: the defendant's adverse childhood and the long-standing depression that he suffered from. Dr. Mackless testified in detail as to all of these adverse childhood effects. There were over 9 pages of the transcript where right after he talked about this mitigator, he went on for 9 pages explaining these adverse childhood situations. Excuse me. And then he went into the depression. But as he was talking about the depression, he kept reverting back to these adverse childhood experiences. He even said at page 3,171 of the transcript, "I know I keep repeating these adverse childhood experiences," as he's talking about the depression. So really the focus of that mitigator was these adverse childhood experiences. So when the court in its sentencing order was assessing it, the court credited Dr. Mackless's testimony, said that the mitigation had been established, but in light of the fact that it was focused on the adverse childhood experiences, the court found, well, yeah, you've had these experiences, but you've been able to conduct yourself accordingly throughout your life with your various jobs and in the military, so that's why he only gave the mitigator slight weight. So given the reliance on the expert's testimony, there can be no legal error as Mr. Bulletin has alleged, nor any abuse of discretion. With the no significant history of prior criminal, no significant history of prior criminal history, mitigator, that was an error with regard to the judge saying, well, given that this was a double murder, we agree that that was error. The problem for Mr. Bulletin, or not that it was error, but that it was incorrect for the judge to do that. The problem with Mr. Bulletin's argument is the judge still found that that mitigation had been established and assigned it moderate weight. So I don't think we can say that no reasonable judge would have assigned that mitigator moderate weight, but if this court were to find so, any error would be harmless given the significant weighty aggravation in this case, HAC, the victim being under 12, and I'm drawing a blank.
It's okay. I think we all appreciate
Yes.
the state's concession.
And the contemporaneous, obviously the contemporaneous murder of Stephanie. So I think that if we were to add great weight to that mitigating circumstances, it would not have any impact on the judge's sentence. The judge found that the aggravators heavily outweighed the mitigating circumstances presented. So I think this court can confidently say that any error there would be harmless beyond a reasonable doubt. And when the judge sentenced the defendant, I think the judge explained, I have prepared a 21-page order with my findings. I'm not going to read it all to you, but suffice it to say that a precious child is dead. The murder was heinous, atrocious, and cruel, and it was done after you murdered his mother, Stephanie. For that count, I sentence you to death. So I think that any additional mitigation here would not, or any additional weight would not have impacted the court's ultimate sentence here. And the state would, if there are no further questions, respectfully request that this court affirm the defendant's convictions and sentences. Thank you.
I'm going to have to go out of order here. Justice Coriel, your point that at most Al Johnson's testimony, had he testified differently, would have corroborated Dr. Matzos, I have to take strong issue with that. The problem, if Al had just gotten in a wreck on his way to the court and not testified at all, then you could maybe say his favorable testimony would have just corroborated what Dr. Macklis said. But what this did is it put him in conflict with Dr. Macklis before Dr. Macklis even testified.
No, I understand. My point is that had he testified the way you wanted, well, I shouldn't say that. Had he testified the way it has been proffered to the court and to the court below, that he testified in the prep sessions, that would have corroborated Dr. Macklis.
I think it might be, yes, but I think it might be a better point to say that Dr. Macklis would have corroborated him, because Dr. Macklis got the information.
I get
him.
it, but I guess my point is that the jury heard the evidence.
But
that's the thing.
The jury heard conflicting evidence. The jury heard two witnesses called by the defense. The primary source said, no, we had a great child and no abuse. Then the secondary source says, well, that's not what he told me before. Who are the jurors going to believe? Maybe some believe Al, maybe some believe Matt, who knows? But the point is Dr. Macklis's testimony, which was crucial to Johnson in many, many ways, was undermined by what Al did. And the state says that the perjury threat occurred after the jury penalty phase. That's true, but what happened is that Al was locked into repeating his jury testimony, which the prosecutor couldn't even say that he believed was true. I'd ask the court to look at particularly the Mohammed case out of this court, the Reese case, which this court cites, Crabtree out of Michigan, and Feaster out of New Jersey. The state says Al never said in the email, he never said, I lied. That's true. Al's a very self-protective guy, and that kind of just bleeds through the pages. He didn't say, I lied. What he said is, I now want the opportunity to tell the truth. But when he had the opportunity to tell the truth, because of this perjury threat, it's as clear that it's like, I might go to prison for 15 years. I might get charged with perjury, and his hostility comes through the pages. The state said something that I think they said that they went back and talked to Mr. Warren, and Mr. Warren said, we'll look into this. I didn't see that. What I saw was the prosecutor at the hearing before when the Spencer hearing was going to take place, said we will charge him with perjury if he says anything different than he said, materially different than he said in the penalty phase. And I know I have to talk to Mr. Warren, but I'm sure Mr. Warren will say go for it.
So, sorry to interrupt you. You can have 30 seconds to finish up.
30 seconds? Okay, we're going to go with this. I'll stay on this subject here. The state says that whether abuse occurred, whether you want to call it abuse, is subjective. I don't think it's subjective. If you're talking about being forced to strip naked, humiliated, whipped with electrical cords, lamp cords, black straps, as opposed to my grandmother was a fine Christian woman who never did anything wrong, and she taught us to love each other, and there was no abuse. I mean, that's not subjective. That's black and white. I'll wrap it up.
Thank you very much.
Thank you.
We're adjourned.
All rise.